Hi, I am Professor Kshitij Bansal and I teach law at Jindal Global Law School. The module that we are going to discuss today is about rules regulating means and methods of modern day warfare, that is the drone debate. Learning outcomes for you after listening to this briefing are as follows. You will learn about the implementation of principles of international humanitarian law vis-a-vis the technological advancement in the modern day warfare and how the legal principles have been evolved to equip this intercourse between law and constant technological evolution. You will also learn about the changing patterns of warfare and how international humanitarian law has theorized legal principles to mitigate the effect of use of technology in war. Many people watching unfortunate stories of civilian casualties in America's drone war in Pakistan and Afghanistan assume there must be a basic right against such killing, or that, at the very least, that international law condemns these acts as illegal. Under human rights law, one might view these targeted killings as extrajudicial killings, or in any case, a deprivation of the right to life. Members of the UN have a charter-based duty to take joint and separate action in order to effectuate universal respect for and observance of human rights. And many are also signatories to the International Covenant on Civil and Political Rights, which sets out these rights in details, including, crucially, the right to life. If we accept the proper lex specialis, governing armed conflict is IHL, not HRL. However, then the matter is not so simple. In IHL, killing of combatants is actually permissible, and even the incidental killing of civilians can be excused based upon some particular principles. This module will explore the IHL-based regulations covering this area of drone war in detail, their current possibilities and their limits, before turning back to HRL for further guidance. The technological post-humanization of war, not the perennial inhumanity of war, but the removal of humans from the battlefield is an issue that IHL has only recently had to grapple with. This section aims to get the reader to appreciate the manner in which IHL has had to evolve to accommodate a change in technology, and where the absence of combatants is accompanied by the appearance of technology precise but legally slippery proxies. This module attempts to ground the understanding of IHL laid out in the previous module in a more contemporary setting, thereby acquainting the reader with how the principles of international humanitarian law are applicable to dynamic changes in technology. This module attempts to use the grounding of the debates to show that IHL's focus has now moved from the banning of particular weapons, which remains rare, to the regulation of the method of their use. So the question is no longer whether the use of a particular weapon violates IHL, but whether its use in a particular scenario was justified and legitimate. The module also goes on to ground the reader's understanding of how these principles, distinction, prohibition of unnecessary suffering, and proportionality, have been adapted to take into account the changing trends. Finally, before defaulting to easier and more reassuring standards derived from human rights law or imagining idealistic but as yet non-existent disarmament treaties, this module urges the readers to think critically about the post-human era. Even if military personnel are put at greater distances from the battlefield, the equally human targets are not. And even if at the moment drones or warbots are not completely autonomous, it is worth considering how IHL would have to evolve in the event that they become completely autonomous. How would notions of responsibility and accountability change? These questions are becoming more relevant with each passing day. The drone debate has its own IHL approach towards it. Over the past few years, as the use of increasingly automated, though not completely autonomous, weapons has increased. Names of these include drones, warbots, robotic weapons, unmanned combat vehicles, unmanned aerial vehicles, UAVs which we call. Their use has increased and become visible in combat zones including Iraq, Pakistan, Afghanistan, and Ukraine. The topic of the regulation of these weapons has pervaded academic thesis, mainstream media attention, and books. Each account provides speculation on the application of IHL to robotic weapons. The need for IHL to evolve to keep itself relevant is historically documented. Any technological change has a tangible impact on the application, on the relevance of IHL. Questions such as where to attribute responsibility in the event of a drone attack is perplexing. Instead of understanding the need for the evolution of IHL, numerous scholars have instead argued that we must ban any form of technological change. Fear of new weapons. The concern is not the introduction of robots into battlefield, but the gradual removal of humans. In this context, the gradual removal of humans implies that humans no longer control the weaponry. This could be problematic in the context of IHL's implementation because using robots implies that there is no control in the means and outcomes, and that there is an inability to impute responsibility to a party in an armed conflict. As a result of using robots, it results in the loss of respect for IHL norms. The groundwork for this fear is the conservative idea that IHL is static and simply cannot evolve to keep up with technological change. What about weapons? Means and methods. Much like the use of UAVs, the latest controversies about new means and methods of warfare have been about either cyber warfare or autonomous robotic weapons. Let's talk about cyber warfare. As a historical matter, the introduction of novel weapons such as escalation of weapon capabilities from fists to stones to nuclear and robotic weapons has always been greeted with suspicion. The earliest warriors, accustomed to conducting hostilities by using each, must have regarded the first appearance of more advanced technologies as violating the laws of war. The latest controversies about new means and methods of warfare have been about either cyber warfare or autonomous robotic weapons. Drone warfare has been vulnerable to this critique. According to Vic Conver, as with many weapons in the past, novelty cannot be equated with illegality. Increasingly, it is no longer the weapon itself that is focused upon, but the method of its deployment. While in the recent humanitarian phase, the chivalrous ideal of the right of belligerent parties to choose methods or means of warfare, like duelists agreeing upon pistols at dawn, is no longer unlimited. Similarly, IHL is no longer focused on the banning of entire classes of weapons. Instead, limitations are placed on the manner of a weapon's use. The key issues concerning the deployment of unmanned systems are whether the use of a weapon is novel or not. Any weapon is subject to the general rules and the principles of customary and treaty law of international armed conflict, as well as to any other treaty law applicable for contracting parties. There are three relevant principles that are identifiable from the principles of customary and treaty law on armed conflicts. Distinction between combatants and non-combatants, and between military objectives and civilian objectives. The prohibition on causing unnecessary suffering to combatants, and proportionality. Further, the HPCR manual provides that weapons used in air and missile warfare must comply with the basic principle of distinction between civilians and combatants and between civilian objects and military objectives. Consequently, it is prohibited to conduct air or missile combat operations which employ weapons that cannot be directed at a specific lawful target and therefore are of a nature to strike lawful targets and civilians or civilian objects without distinction between civilian and military objects, or the effects of which cannot be limited as required by the law of international armed conflict and which therefore are of a nature to strike lawful targets and civilian or civilian objects without distinction, or the prohibition of unnecessary suffering or superfluous injury. Consequently, it is prohibited to conduct air or missile combat operations which employ weapons that are calculated or are of a nature to cause unnecessary suffering or superfluous injury to combatants. Formally, IHL would require at a first phase the analysis of whether a weapon is of a prohibited nature and then look specifically at its use according to a separate analysis. Article 36 of the Additional Protocol 1 to Geneva Convention, which advocates a preventive approach by requiring contracting parties to determine whether the study, development or acquisition of a new weapon would be contrary to the provisions of the Additional Protocol 1. There is no automatic prohibition on robotic weapons. One must first find instances where these weapons cannot be properly targeted or cause excessive injury to see how intrinsic these characteristics are to the technology itself. Indeed, is no automatic prohibition on robotic weapons. One must find instances in which their use would be indiscriminate, disproportional, or cause excessive injury, rather than focusing on whether certain characteristics are intrinsic to the weapons themselves. As the development of unmanned weapons accelerates, it may be time to reverse the order of conduct. Nature analysis once again. In the meantime, it is not IHL but treaty-based regimes that would ensure that their very use is put into question. The most reliable way to outlaw the use of specific weapons, or at least ensure their review, is for states to pursue a multilateral convention banning or stigmatizing weapons of that kind. Therefore, it is important for the reader to note that when IHL is imagined outside the static box of the fear thesis, it seems to accurately regulating a scenario where excessive force is used through a drone attack. Next would be about law, war, and the technological change. Automation of warfare does not yet mean complete autonomy of weapons. This distinction will be discussed in the detail later on, but rather it focuses on at least some life and death decisions that are made by that warfare technology on the battlefield without direct input from humans. What is referred to as autonomy is not artificial intelligence capable of supplanting human responsibility. Instead, it is an increase in time and distance between human actions and the results. In particular, there is an assumption that agency or responsibility should be distributed as though robots are combatants rather than weapons. Singer sometimes confuses the matter by taking an overly anthropomorphic view of autonomy, treating warbots as the most irregular form of combatants. Rather than being artificial persons, such as states or corporations, they more clearly belong to the category of weapons whose use is considered an extension of human action as means and methods of combat. Technology has already distanced soldiers spatially and temporally from the killing they cause, increasing asymmetrical safety between belligerents. Given the speed of technological change, anticipating the advent of autonomous weapons might not be a bad idea, and interventions might be sought in the engineering of norms as well as technology. The greatest obstacles to automated weapons on the battlefield are likely to be legal and ethical concerns. Forward-thinking scholars have taken up the challenges resulting from the interplay of law and technology in this instance. Both rules and weapons can be retooled to accommodate each other. The continuing possibilities of human rights law. We have noted in the previous modules the dangers of muddling humanitarian law with human rights law or the law of self-defense. Indeed, the US has a parallel justification for the use of drones grounded not in IHL but in the law of self-defense. But perhaps the last hope to restore humanity in this debate is to look at the issue from the point of view of not weapons law, but the law of targeted killing, and therefore human rights law once again. For example, using an HRL approach, a recent Amnesty International report urges the US to conduct a thorough, impartial, and independent investigation whether certain CIA personnel may be guilty of arbitrary and extrajudicial executions in violation of international law. The advantages of human rights law would lie in that it applies at all times and in all contexts, including during war. For example, there are no geographic or contextual limitations with respect to the UN Charter-based duties of all the members to take joint and separate action in order to effectuate universal respect for and observance of human rights. The preamble to the International Covenant on Civil and Political Rights, ICCPR, of 1966 affirms this universal approach. How practical is this, however? Should drone attacks be treated as arbitrary and extrajudicial executions under HRL? It might also seem that because the current targeted killings are not in the context of a classing armed conflict, which leads to an even greater presumption that HRL might be the appropriate body of law here, but problems arise in this approach. If we switched to an entirely HRL-based approach, we would treat the question as one of domestic law. But whose domestic law will it be? Let us take the example, however unlikely, of an American drone strike in India. What law would actually be applicable? We could refer to the Indian domestic law, under which for any deprivation of life and liberty, there must be a procedure established by law, which is not arbitrary and unreasonable. Or else, we could seek extraterritorial application of the US Constitution, particularly the parts of the Bill of Rights concerning due process and punishment. The Fifth Amendment, grand jury, double jeopardy, self-incrimination, due process. Sixth Amendment, which is criminal prosecutions, jury trial, right to confront and to counsel. The Sixth and the Eighth Amendment, excess bail or fines, cruel and unusual punishment. In these ways, the general human right to freedom from arbitrary deprivation of life will only be applicable with those persons who are within that jurisdiction, actual power or effective control of the state or other entity using a drone. Faced with these choices and the unlikelihood of being able to prosecute the handler of a drone strike as someone conducting an execution, the only option left are to privatize the killings, thus invoking domestic criminal law or fall back on IHL. Under IHL, many targeted killings are considered lawful, including targeting of those who are taking a direct part in hostilities. Those who are directly participating in hostilities and are targeted during an armed conflict. If we apply a separate regime of self-defense, which is part of the American approach in reality, then it is possible to target those who are taking a direct part in the ongoing armed attacks. That is, those who are DPAA and are targeted during permissible measures of self-defense in the time of peace and war. What about a convergence approach to IHL and HRL then? If convergence means convergence and not the eclipsing of one system by the other, then the most likely reading is that if human right to freedom from arbitrary killing did apply, lawful targeting of such persons in compliance with the principles of distinction, reasonable necessity and proportionality under the law of self-defense or laws of war will not be arbitrary within the meaning of human rights law, that is, within the meaning of Article 6 of ICCPR. Additionally, compliance with the principles of distinction and reasonable necessity and proportionality will provide a higher form of protection than a general human rights test based merely on what is or is not arbitrary in a given circumstance. This leads to a certain kind of circularity and ultimately it remains largely within the ambit of IHL. What are the other possibilities in international law then? Some authors think that the deficiencies of international humanitarian law, IHL, which gives weak guidance and insufficient constraints on these weapons, need to be addressed by future arms control agreements limiting the use of autonomous weapons. If we were to develop treaties, we must define autonomous weapons under international law and agree on permissible roles and functions of these weapons. First, the scope of the treaty would rely upon an agreement on a definition of a robotic or autonomous weapon. After arriving at a definition that is both precise enough to exclude irrelevant technologies while capacious enough to include future developments, the real challenge will be the content of regulation. When should the armed forces be allowed to use them, for example? For example, states might bind themselves to use autonomous weapons only for defensive functions, such as guarding military facilities or safeguarding no-fly zones. Another approach to arms control agreements has been to limit the number of weapons, a step that states might take to prevent letting loose too many uncontrolled or poorly monitored weapons in the world, maybe letting the Hollywood fiction stories coming true. An analogy could be made to the continued development of nuclear weapons, even as there have been effective international pressures keeping their use in check since the end of the World War II. It is unclear, however, whether such an analogy represents a model for effective deterrence. On the one hand, nuclear weapons have not been used. On the other, stockpiles have continued to develop and increase despite the supposed limitations. A third approach would be to use autonomous weapons only for difficult humanitarian missions, not involving the use of force, such as the cleaning of landmines. Such agreements would only work if states could agree upon definitions and classifications, and if these definitions keep pace with changes in technology, most importantly. At the moment, the present generation of drones has not inspired a significant movement towards an outright ban, as in the case of landmines and cluster bombs, for example. Nor do we see states adopting subtler schemes for limitations on numbers or monitoring and compliance schemes. Some authors have even imagined that the technology itself could be programmed and guided by the rules of IHL. In the recent book, Ronald Arkin is optimistic about the compatibility of autonomous weapons with international law and conventions of war for non-proliferation. He believes that robots can be created to not only conform to international law, but to actually outperform human soldiers in their capacity for the ethical rule-based use of lethal force. He puts forth a positive agenda for designing an autonomous system programmed with artificial conscience based in part on the rules of international humanitarian law and weapons law. Sounds interesting and optimistic indeed. Arkin provides examples that illustrate autonomous systems' potential to internalize respect for ethical use of force, including relevant laws of war, and is just as pessimistic when he examines why soldiers in battle fail regarding ethical decisions. Arkin's utopianism remains a step ahead of the futurism of the other authors reviewed above, but questions remain. In the event of a failure, should IHL follow the designer or the unit used to deploy the weapon? Arkin avoids an implication that whatever ethical imperatives are programmed as, a weapon whose use or misuse cannot be attributed to any human agent is dangerous from the outset. This brings us back to Singer's intuition that putting humans at the distance from a battlefield endangers compliance with the governing rule system and the applicability of the rule system itself. Feedback loop between IHL and technology in warfare would be an interesting step to discuss now. The introduction of sophisticated robotic weapons into combat introduces sufficiently profound changes in the conduct of armed conflict to pose a challenge to the existing IHL. It is possible that the law will expand to incorporate that which arguably was previously outside its reach. One suggestion would be to look beyond the weapon to find the human agent responsible. Here, the question of applicability of IHL must be revisited at each instance. This includes the unlawful participation of civilians in hostilities. For instances in which human agency becomes so attenuated as to seem disappear from view, attribution must be identified under a complex variable in which deployment must be traced and programming stands in for command. This extension of law is already at work and may reach civilian computer technicians thousands of miles away from battlefield. With modern technologies such as long-range missiles and unmanned missile-bearing planes, the focus on a well-articulated weapons law is useful to IHL, which has always struggled to keep pace with technological innovations in the means and methods of combat and warfare. How can we conclude now? Succinctly, we've learned about the novel strategies used to conduct warfare in the modern times and the resultant reactions from the global community assisting in restructuring of the legal principles which are conducive to equip the states to mitigate the use and impact of technological advancement. Further, citing major recent outbreaks, we learned about the novel yet lethal modus operandi used in the name of technology that has most certainly made it difficult to pin the consequential responsibility. It is essential to begin with deliberations and modifications to the international legal framework which can assist a state or the international community as a whole to shield themselves against overarching use of autonomous warfare or cyber warfare, posing a big threat to the global security at all times. I hope this was interesting and useful. Thank you for listening.